So Clarence Thomas has been a subject of inquiry ever since a couple years ago when ProPublica found that he had taken, at that point, roughly $500,000 in undisclosed gifts and travel from a billionaire friend of his. This has since expanded. We've learned about more gifts, the home that is given rent-free to his mother, the tuition that was given to him to pay for his nephew who he was raising at the time, the RV that was co-signed by a healthcare executive and, as far as we could tell, fully paid off by that person. At least Thomas has not provided anything to suggest otherwise, despite multiple requests from Congress. So this is obviously a problem. This is a situation where there is a law that governs the behavior of the judges and justices that requires them to disclose this material. He had not been doing it. He'd been keeping this all under the radar, likely because he understood that it would appear wildly corrupt, which it has. The Senate has asked the Judicial Conference, in its attempt to get anything and any movement out of this ethical quagmire, it asked the Judicial Conference to exercise its power under the statute to refer its members to the DOJ for inquiry. Then the FBI can look into all this and prepare charges if necessary for violating this act. This dragged on forever. The Judicial Conference responded over the holidays to explain what it's going to do.
Nah.
Exactly. In a letter sent to Sheldon Whitehouse was the chair of Judiciary Committee on this subject. He was looking into this. He got a letter from the Judicial Conference in which they said they mused that they may not have had authority to send a referral of a justice, arguing that despite the fact that the law says they can do it for anybody it applies to and it applies to justices, maybe it doesn't really mean they can do it for justices. But that's not actually the crux of what they say. The actual decision is we put out new guidance. You know, it wasn't clear before that you weren't allowed to take millions and millions of dollars from people with interests before the court. I mean, it was a little vague when they wrote this law in the 70s. And so now that we have new guidance, we trust that he'll never do it again. And therefore, we don't think it can be sent to the DOJ to investigate when he did it before.
That is wild.
Yes.
I mean, this is a real problem that it's very clear at this point that the justices on the Supreme Court can do whatever they want. There is no ability for, common decency, laws, senators, even presidents to check their behavior, right? There's literally nothing. And we've kind of used this line a bunch when talking about the court, but, being a Supreme Court justice means never having to say you're sorry. They can do whatever they want. It doesn't matter how corrupt it appears. And let's not forget that the standard for ethical behavior for the federal judiciary is meant to be the mere appearance of impropriety. It's not, oh, he got a tit for tat, you can't prove this. No, it's supposed to be, it looks bad. And you know what this does? Look bad.
So to explain this new guidance argument, the law says that you have to disclose all of these gifts you get. It's Justice Kagan once got a care package from her high school classmates when she was, down and ill. There was a bunch of bagels, and she returned it because she felt like that was in breach of this law. So to give a sense of where everyone else's head is at as far as what this law means. But it has a personal hospitality exception. And what the personal hospitality exception was intended to be is, you're crashing on your buddy's couch. You don't really need to report that. You go over to your friend's house for dinner. That's fine.
Right. Because you still have a life.
Right. What Thomas has done historically is claim that these billionaires that he only knows by virtue of being a Supreme Court justice, that these billionaires, when they give his mother a house or when they buy him an RV, that is just, personal hospitality. This is something that, according to this report, he was unaware of and that they needed to present new guidance for. It is what the rest of us think is completely obvious.
This is not a hard call. And listen, the problem is that, again, no one is willing to hold the court's feet to the fire in any sort of a real way. The court has said, Justice Alito in particular has said that there's no other bodies could possibly have any ethical guidance that the Supreme Court should have to take seriously. Mm-hmm. And the other options, which are things like, the power of the purse that Congress has. And if you want, your increases in your security budget and you want, all your clerks paid for and all that kind of stuff, well, you have to meet these following requirements in order for us to justify these expenditures, is not something that Congress has the political will to do, and certainly not now that it is controlled by the same party that appears to repeatedly have these ethical lapses. So all we can say is, and the approval rating of the court just keeps on getting tanked and tanked and tanked because it's incredibly obvious to everyone that this is a problem.
I think Luigi Mangione has a higher approval rating among young, and that's not even a joke, young Americans than the Supreme Court.
So I want to fixate on those two points as a matter of transition. But before I wanted to do that, I wanted to say my story, which you could all read to get more analysis on this, focuses on a Seinfeld framing, largely that George Costanza once did something that was obviously wrong, but not necessarily spelled out wrong, and responded with, "Was that wrong? I didn't know that was frowned upon." And that is exactly the excuse given here. I thought that was fun.